The internet made the entire IP system look completely obsolete, created a space which is borderless and different. Where do you sue? Can you sue in every single jurisdiction based on the law of that jurisdiction? It becomes practically possible in California. You are the owner of your brainwaves, neuro rights. Can you believe it? So imagine when you are talking about neuro rights, we are still registering patent country by country. We are using a quantum computer and then going around with horses.
Welcome to Talk IP to Me, the podcast where we break down intellectual property so it actually makes sense. My name is David, and today we are diving into emerging tech in art and copyrights. And today I'm joined by Massimo Sterpi, an Italian lawyer specializing in intellectual property and new technologies and art law. Massimo is a partner and head of IP at Gianni and Origoni in Rome and has litigated over 250 IP cases across borders. He is also a passionate art collector, as I understand. Welcome, Massimo.
Thank you.
Thank you so much for accepting our invitation. Most of your interviews or most of your conference speeches start or include the sentence that artists are the R&D department of humanity because they are early adopters, curiosity and innovation are baked into them. And I'm so interested in, when did that idea come to you first? What drove you to actually say that?
Actually, I'm very happy to start with this very interesting quote because that, let's say, is the explanation of the evolution of my career. I started as an IP lawyer 30 years ago. IP was much more traditional, was the new kid on the block at the time. It was booming. Patents were already starting, but there was not an industry around patent. And at the same time, from very early age, I started collecting art, contemporary art, and the two things seemed to me a bit separate. I also started seeing that artists were not, let's say, closed in a corner and just painting and sculpturing like 1,000 years ago, but they were really very curious people and they were embracing the newest technology. So at some point, the two areas were not only parallel, but at a certain stage, especially with the arrival of artificial intelligence, blockchain, and then the metaverse, the artists were early adopters. So as I said in another conference, art law moved from a corner of the legal, let's say, arena into the center of the legal arena because it became a playing field, a testing field. So the first attempt to try certain technology happened in art. I'm just making two examples. For the, let's say, genetic modification and the creation of a, let's say, a transgenic sheep, that was not done in a laboratory by scientists, but actually was first made by an artist, a Brazilian artist, that actually presented that sheep not as an animal, but as a sculpture. And presenting it as a sculpture modified the entire environment. People were a bit, as a sculpture, it had a much wider liberty and it was much less criticized rather just being the result of a scientific experiment. But another example is the NFTs. The first use case on a very large scale of NFT was in the arts. When the generative AI appeared on the market and everybody was shocked and didn't understand what was about, for me, it was nothing new because imagine that I already made a conference at the Ford University in 2014 that it was entitled The Rise of the Neural Artist. That was art being created through neural networks. So actually, I was already aware, but through arts, not through technology, which was an interesting thing. So at this point, I believe that art and technology are more and more intertwined so that this double competence is very much understanding in both areas.
That's super interesting, especially that you've already held a conference or a speech at the conference about the art generated by neural networks, as I understand.
Right.
That's just so crazy. Walk me through what happened in 2014 or around that time regarding AI or Gen AI and art that actually prompted to have these conferences and talk about the actual art that could be potentially created by Gen AI. And then now, 12 years later, we are seeing it every single day. It's on our screens, literally on social media. So what was there 12 or 13 years ago that already the artists saw, perhaps?
So these were two computers, basically. One that was mixing randomly images that were provided to them. And here you have the issue of training over the AI that is current today. And it was called the creator. Artificial intelligence is not creative. is recreative, meaning that it recreates by aggregating pre-existing material. And what looks to us as something creative is just actually a simulation of what has been created before by humans. But the delta between the AI creation and the human creation is the conveyance of meaning, because the AI has nothing to say. If it is produced images, they are images. If human produce images, those images can become artworks. And an artwork is an image with a meaning. I think this exercise also help us understand what is our relationship with art, with artworks, what is the human nature, what is our specificity compared to what can be simply reproduced or mimicked.
That's so interesting to say, because we also know that every single AI model has some sort of training data, and then they're using that training data to generate new images or perhaps art or some sort of content. But on the one hand, you've got these artists that perhaps 12 years ago have already seen what's coming in the future and pushed the boundaries and thought with immense creativity about the future. And then on the other hand, you have the administration and the law that is moving a little bit slower than artists are pushing the boundaries. So you sit this intersection, but how do you see the imbalance between the speed?
The imbalance between the speed is natural when you think the speed of technology can be really rocket speed, whereas approving law, especially for entities such as the European Union, is a very long process and is a process of mediation where you have to mediate many conflicting interests. So that's normal that the law follows. And by the way, after the LLM, and now we have already another sudden news, which are AI agent or agentic AI, which is a third level, which are still having and raising different issues. So the law has certainly difficulties into following technological development. The other thing that I see very much, and also as an impact of what I'm doing, and also on my professional activity, is that IP law has a very strong concept on territoriality. Okay, it's based on a territorial differentiation. But all these systems entered in a big crisis, not now, but from the advent of internet. Internet created a space which is borderless and different from anything we learned before. And at that point, when an image is put online and is visible for the entire planet, where do you sue? Can you sue in every single jurisdiction based on the law of that jurisdiction? It becomes practically impossible. On top of that, the identity of the infringer is 99% of the cases unknown and impossible to find. So the challenges that raised with the internet were immense because they made the entire IP system look completely obsolete. The only legislation that had already almost worldwide application was copyright law through the Berne Convention that has almost worldwide application. But patent law, trademark law, design law, where you need to file and cover every single country with different law cost, etc., is completely obsolete at this point. And that was the beginning of the crisis of the intellectual property. What are the rights that are now on the rise? Actually, copyright, not only artistic copyright, but technical copyright. For instance, software or databases, which are a very important part. I put a signboard in my new office saying data are the new IP. Yes. And actually, this is very true. Data,
Very accurate.
yeah. Why are data so central? Because AI is the combination of two elements, an algorithm and pre-existing data. Without pre-existing data, the AI cannot work. So clearly, data became the fundamental thing. You know, anything that has no territorial limitation, like domain names, copyright, trade secret, format rights, image rights even, is growing, whereas everything that is linked to territorial registration is going very much down. And in the last 15 years, the big battle has not been on, let's say, finding lawyers that were competent on IP, but actually reducing cost. So everything linked to procedures and repetitive activities has already became a commodity, very much a commodity. Now we have artificial intelligence that is certainly going to substitute or, let's say, create much less human work in repetitive tasks. So clearly that there is already been a sea change in the IP market. And that's why our department that was originally IP became IP and new technology. We have a very big data protection and cybersecurity department. And we are moving more and more into technology. Technology is still very much unexplored, and there is a big, let's say, step to enter, because actually you have to understand the context. I make an example. The last thing I was talking about is neural implants. Okay, neural implants that were initially conceived just to remedy illnesses or traumas or things now are being already used to, let's say, improve human capabilities. But these implants or peripheral system that can communicate with the human brain also, let's say, attract and register human reaction, so the brain activity. At that point, okay, we have a very wide concept of personal data within the EU that certainly covers our brain waves. But in many other places in the world where there was no data protection or no privacy law, it was very much uncertain if these brain waves were the property or not. So actually, there are legislation, for instance, in California, saying that you are the owner of your brain waves. So imagine a new kind of that. And now there is a movement already also at the European Union level that are lobbying to create a new notion of neuro rights. Neuro rights, can you believe it? So we are moving into new areas, okay? So imagine when you are talking about neuro rights, we're still registering trademarks or registering patent country by country. We are using a quantum computer and then going around with the horses.
I think that's just so fascinating, especially because you touched upon copyright, patents, trademarks, and how it actually technology changed the whole work IP managers have been and are doing right now. But one thing that's really stuck in my mind is if I am, let's say, an artist, an up and coming artist that wants to now navigate this kind of very much turbulent times and technologies, how do I know if I can use AI to support my work? And let's say my art is AI assisted. And how do I know if I'm not qualified for that? And should I completely scrap AI and not use it at all? But then perhaps I will be at a disadvantage at my, let's say, productivity level compared to others. So where is the balance in all this? How much can I own as IP, or how much assistance should I perhaps use in order to create art?
Actually, you have two problems. The first problem is actually the legitimacy of the sources. And the second is if using AI as an artist, you can still pretend to have copyright on the output. Actually, on the first issue, of course, the debate is very much ongoing. Much depends on the source you are using. Some of these systems already, let's say, protect the user, saying that they will take responsibility for any unwanted copyright infringement that emerge from the use of the tool. And some of the tools are already implementing filters that before releasing an image or a text, they check if the text is too close to some material that pre-existed. So is the source tool. So actually you can use it and you should have a look to the terms and conditions and understand whether they guarantee that you are safe by using that, etc.
So there are AI tools out there where in the terms and conditions, it specifically says we are using filters to monitor for copyright infringement, and whatever is produced is guaranteed that won't
Actually,
infringe.
if I remember correctly, that was already offered by OpenAI to any commercial license that was taken. So if you subscribe a commercial license, they were protecting you from any claim related to copyright infringement. I think that's a very wise model. There is no other way the user can know. And for them also that offer can be insured. They can subscribe an insurance policy against legal claims. And by the way, I do not believe that legal claims will be so frequent also because the mixture tend to be quite advanced. Even if you have certain prompts like create a work in the style of that can generate other problems. But in general terms, I've been working with artists recently that were using AI to create religious images under prompts, and then the images were taken by the artist and painted on the walls, like digital chapel, okay? What I call the church of prompts. That was advising on here in Rome. It was quite interesting.
I think that will be the title of this podcast.
The church of prompts was actually the title, so that is direction. And so there are, in a sense, artists decided that he was submitting himself to AI. So he was prompting the AI, taking the image and repainting the images, just as he was the robotic arm of the AI. By the way, this was very much in anticipation of this site that has been recently launched where AI agents are requesting human volunteers to implement the activity that the AI agent want to implement, but need physical arms. And already in a matter of 1 week or 2 weeks, 250,000 humans already volunteered to become the arms
Wow.
of an AI agent. You see that talking about trademark registration at this point sounds a bit weird.
Yeah, and that also brings me to question if I, for example, as an artist or just a volunteer, look at that and then an AI agent tells me, do this for me in the physical world, I do it, then who owns that?
Actually, yeah, no, that's interesting. Actually, the mere fact that a general principle of copyright law, the mere executor is not the author. The author is the one that gives the direction and has the final control on the output. So if the final control is on the AI agent and the instruction as well, there will be no copyright protection because now the principle has been quite shared by many courts around the world that without human intervention, there cannot be copyright protection. So in general terms, that would be a scenario, but here it was more sophisticated in the Church of Rome because the artist was giving the prompts, even giving other prompts to refine the image, taking the image and painting the image on the wall. But at that point, the artist was at the beginning, at the end of the process. The machine was just a tool used in the process.
Actually, this is also basically a two-sided question, right? Because now I'm, as an artist, perhaps able to create a lot more art or generate a lot more ideas quicker. But at the same time, my art pieces that are already existing, they can be used as training data by other agents or other LLPs, and there is a much higher chance for infringing my copyright.
Yeah,
Would that be fair?
That's one of the big issue, in my opinion, which is unresolved and should be resolved in some fair way. The fact that to train AI, like copyrighted content was used without recognizing anything to the original creator, in my opinion, is completely unfair. And in fact, the big platform already started licensing quality content. They licensed the New York Times archive. They licensed big news agency archives. Some of them are licensing a big image bank. And that would be the first solution. You have seen that there has been a decision in the state about use of books for training of AI. And actually the interlocutory decision, which is in a mediation, actually, it's gigantic, it's in the hundreds of million range. So if it can become the start of a class action, that can bring some value back. And I believe that that will be the fair solution because the idea that everything can be used to train the AI that has endless value. Why does it has endless value? Because it was generated for free by not paying the material they used. It's like to build a building without paying the materials, without paying the steel, the concrete. Of course, it costs little. You stole everything and then you build a building. Oh, construction cost, it was just human work, but the material costed nothing. Wait a second, you have to pay the materials. So the building blocks were used for free, and the excuse was rapidity. It's very interesting to remind that there are some messages that were published in some investigation in the US where the CEO of this gigantic company was saying, we know that we're infringing, but let's do it and then we'll find a solution. Okay? So infringe first, but create the working model, and then we will find a solution. I hope that now that the model are there and working, a first solution will be found to remunerate the creator for the use on this gigantic scale their works.
I think we are living in such an interesting time. And one of the things that you mentioned in the beginning of this conversation was the territorial aspect, not disappearing, but having less and less effect because of globalization. So how does that impact all this? So let's say a jurisdiction or a law only has effect in a specific jurisdiction, and there are some international treaties that perhaps many countries have joined. But let's say someone from a less developed country or a developing country is stealing my copyright that I have been producing myself. So what do I do as an artist then?
Clearly, the territorial nature means that, for instance, a patent is not protected in Belgium. In Belgium, I can exploit the patent freely, and I cannot come and say, yes, but I have a patent in Italy, in France. Yes, but you don't have protection in Belgium, so you have nothing to complain. Copyright is the exception because through the Berne Convention that is basically subscribed by 160 countries or a similar number, there are very limited number like Somalia or North Korea. The number of countries that do not adhere are really limited. So through the Berne Convention, you can enforce copyright basically everywhere in the world. Of course, it is worth doing that. But for the other technologies, the situation becomes very weird because the AI Act applies in Europe. The United States decided not to have a federal legislation on AI, but then they have all national legislation, which is a nightmare because basically you cross from Ohio to another country and then the law changes. How can you develop something that change from state to state? Actually, the European Union found this solution that already was applied with the GDPR, which is called the Brussels effect, meaning that even if you are able to do certain things outside of the European Union, if you want to offer your services or deliver your product within the EU, you must comply with the EU law. Meaning that for a big multinational corporation, if they want to put their product or services on the global market, they must be compliant with the strictest law. And the strictest law in this case is the European law. And this is called the Brussels effect. So Brussels effect has the advantage of creating a de facto worldwide global standard. And in a sense, like it or not, at least is a standard. Because I believe that for corporations and startups, what is actually very dangerous is not to have a restrictive legislative framework, but is to have no legislative framework. Because if you create something and then a law arrives and say that what you are doing is illegal, everything crashes, you know? And that's actually the risk that the entire AI industry is running in the United States, because they are all running on this hope that what they are doing would be considered fair use. But actually, first decisions that are out were not in that direction. The US Copyright Office already warned that many of these uses of previous content for training purposes cannot be considered fair use. So what happens at that point? Probably they will legislate retroactively because, of course, they have to avoid the crash of such a big industry. And the same problem already occurred with the blockchain, and not so much the blockchain, but the cryptocurrency. As the cryptocurrency had no legislation, actually people were very much reluctant to adopt them because now Europe finally has a framework. But for years, people were putting money in a field that could have been considered illegal. I don't think that the absence of any, at least framework, and not necessarily very precise and restrictive legislation, but at least a framework legislation can certainly be appreciated by someone that wants to operate in that area.
Mm-hmm. And if, let's say, the future of IP legislation goes towards these international, like more broad frameworks, do you think there could be a change in the tendency that you mentioned, that you are litigating more and more trade secret cases instead of actual patent, design, utility model, or trademark?
Sure, but let me tell you one thing, which is very much the elephant in the room. Protection of algorithm is very complex. They are mathematical formulas. So how they are protected? Under patent law, in many countries, they cannot, unless they are transformed into computer implemented invention. And can you protect them under copyright law? Not necessarily. And normally, the best way to protect them is through trade secrets. Because through trade secrets, you can avoid people having access, and then you can perpetuate through secrecy for an unlimited period of time. But at that point, what are your enemies? Your enemies are your employees moving from your company to another. And this is, by the way, out of the 50 cases we had on trade secrets, probably 45 were involving people that moved from one company to another, bringing with them too much. And now also, whereas if you brought with you a photocopy of a drawing, it was difficult to track. Now everything passes through digital means. So at this point, you leave traces of what you brought with you. And so our work is becoming much more complex. And that's why when you talk technology law, is no longer a law, is an industry where you need to know all the law. Same with art, to make an example. In art, you need to know civil law to do a license contract. You need to know criminal law for a counterfeit, for instance. And you need to know administrative law when you try to export a painting and they block it because they declare it a national treasure. You cannot say to your client that have a collection that they've got a fake, trying to export another thing, and then is willing to get a license, that you are just competent in one area. You need to become competent, let's say, horizontally. More than siloed skills, I see an emergence of industry skills, which are horizontal.
So what you're saying is the future of your work is essentially becoming a lot more generalist instead of going very deep in a specific area.
So it would be industry. In the industry, not everything. It's a different concept because you want an holistic approach from the lawyer. You don't want to go to a lawyer and say, okay, for the trademark license, I can do it. But for the fakeness issue, go to another one. No, they don't want that. They want you to be able to resolve the issue.
I think a lot of people that might be listening to this episode will ask themselves, okay, but how can I do that? Being an industry expert and then being a legal expert at a lot of different subfields, how do I do that at the highest level possible?
You have to develop a curiosity for the industry. And then you bring it to the table when you meet the client and they see that you understand what we are talking about. By the way, I also say to my younger associates, that was very much true under a psychological level when I started working with artists. When they come to a law office, for them is to go to the dentist. They say, oh my gosh, I'm a free person. I'm a creative person. I don't want to talk to a lawyer. The lawyer will laugh about what I'm doing. I do abstract, I put 3 lines, and they will say, what are you doing? And the difference was that I was very much into that. I was connecting. I was going to shows. I was reading. I was already getting information about the artist if I didn't know it before meeting him. The fact that it was respectful, I understood what they were doing. They felt welcome. They felt understood. And then, of course, they delegated to me the solution of the problem. But the same applied to every category. So I always suggest to my colleagues, select a field. It can be fashion, can be design, can be space, can be, I don't know, pharmaceutical. Everybody has his own field. And become conversant in that area, okay? And then, of course, you will apply your legal skills to a knowledge of the area. I believe that before, that was an advantage. But in the future, it will be a basic need.
I think that's such a nice way of summarizing what needs to be done for patent practitioners or IP managers or patent counsels. And with that, I would like to move to the second or the last part of this episode, which would be rapid fire IP confessions. Just very short questions with very short answers. I want your top of mind answer. That could be a word, a sentence, or even just a thought. So nothing too detailed, and I will try and make it as relevant as possible to this conversation.
Sure.
Are you ready?
Absolutely.
Okay, so first question, patents or copyrights?
At this point, copyrights.
One habit you love to see with clients you work with?
Let's say respecting your knowledge and especially these days where they come with a pre-written opinion by ChatGPT. And that's sometimes a bit weird. And normally, let's say, aggravate the cost because not only you have to give them advice, but you also have to prove that ChatGPT or similar was wrong.
Oh my God, I love that. That could be a completely new episode. The first advice you would give to a software company trying to keep their trade secrets?
Actually, regulate in writing. Software developers are particularly bad at that. We recently litigated a very big case where the company showed up and said, I own the copyright on this software. Okay, it's like, okay, can you prove it? Because of course, as a company, you cannot own a copyright. The copyright is created by a human. And then if it is an employee, that you own the copyright. Who developed that? They had no idea. And they were unable even to track back to who was the person or the people that work on that. So this is a big thing that is recurrent. We see that very much in due diligence. Most of the time we say, actually, we have no evidence that we actually own the copyrights on this software.
Regulating and having a paper trail can go a really long ways in the future.
Absolutely, the chain of title.
Okay, I have 2 more questions. One is more personal and one comes from our last guest. What can patent offices do better in the communication with attorneys or IP owners?
Let's say that the IP offices tend to be a bit slow in responding. And actually, what is absolutely unacceptable is the dragging on of the procedure, because the uncertainty is like the denial of the protection that people are seeking. So certainly the speed of the response would be the milestone of a progress of their activity.
So the very last question is a more personal one. As an art lover, is there any piece that you would love to see in your living room if budget and perhaps legality wouldn't be a problem?
It will be probably the next piece I will casually encounter in an art fair or in a studio visit and I will buy.
I love that. I love that. Thank you so much, Massimo. It's been a pleasure. It's been such an insightful conversation, and I hope our listeners will also find your takes very valuable. Thank you so much for joining. Thank you for taking the time. Before we round up, anything you would like to highlight or anything that you haven't shared that you would like to have as the last word?
I think we went around many issues, but probably the last word is that remember that clients only pay for what they do not know. meaning that being always on the next new thing will put you in a much stronger position rather than focusing on things that have been around for decades.
Fantastic. Perfect, Massimo. Thanks again for taking the time. And to everyone else listening, thanks for tuning into this episode of Talk IP to Me. If you enjoyed this episode, feel free to share it with a colleague or a like-minded person, and we'll see you in the next one.
Thank you.
Thank you.
Bye-bye.